Hello, everyone. Thank you for joining our panel on generative AI. Today, we will walk through some of the hottest issues we've been grappling with in the past few months. We'll examine the evolving legal and regulatory landscape, the open source versus proprietary AI debate, and consider how all of this impacts software development and best practices. Any questions you have, put them into the chat. We'll try to address them during our discussion. And we will also reserve about 10 minutes for our Q&A, so we can take them up then as well. I am Giovanna Fessenden Fairbank, Digital IP Counsel at Hamilton Brooks Smith & Reynolds. And for those of you that may not be familiar with us, HBSR, we are a Boston-based IP firm with over 40 years experience in helping companies protect and commercialize innovation. Our team of engineers and scientists turned patent attorneys work at the intersection of law and cutting-edge technologies like AI, semiconductors, biotech, pharma, quantum computing, optics, you name it. My background is in software, and I've been practicing as an intellectual property attorney, patent attorney at HBSR for over 20 years. I focus on AI, emerging technologies like blockchain, semiconductors, open source compliance, and digital health. And I'm thrilled to be joined by this incredible group of experts. Let me briefly introduce our other panelists. They all have deep experience in law and AI. So Mary Lou Wakamura, also from Hamilton Brooks Smith & Reynolds. She is one of the most respected US patent attorneys. She has decades of experience in guiding clients in IP strategy. Phil Mazzocchi, also with HBSR, is a seasoned intellectual property attorney and strategist with a practice that focuses on computer engineering and AI-driven innovation. We're also joined by Leslie Long, in-house counsel at Dassault Systems, a global leader in 3D design, simulation, and digital twin technology. Leslie works at the intersection of AI, data governance, and compliance in product development. And we also have the esteemed Steve Kurowitz, Chief IP Counsel for Kyndryl, who brings deep legal and technical expertise in cloud and AI systems. So without further delay, let's get started. We've seen a series of lawsuits by authors and creators related to copyright and AI training disputes. And there are some real interesting developments coming out of the Northern District of California lately, particularly in the cases filed against Anthropic and Meta. And I realize these are only at the district court level, but are we seeing any trends as to whether machines have the right to learn? Any legal clarity when it comes to training AI models on copyrighted works without permission? So I'll give it to the rest of our panel. Steve, would you like to opine?
Clarity is a funny word here. We have two summary judgments out of the Northern District in late June of this year. Consistency, yes, both found fair use in the training of AI models using copyrighted works. They diverge a little bit as to, in my mind, as to how far the scope of fair use goes. In the Anthropic case, Judge Alsop seemed to be favoring limiting that scope to the actual training. So if you had authorized copies initially, you could then make intermediary copies without, you had a defense for copyright infringement for that act of intermediate copying. And then the act of training using that intermediate copy that you made was covered by fair use. Um, he made a very clear distinction that, quote, pirated works, unauthorized works were not covered, and that should go to trial. That won't happen as Anthropic settled that case, which is now I believe the settlement is final. Alsop didn't like the first version of it, sent them back to clarify uh, the summary of the plaintiffs. It's a class action. Um, Finally accepted that, and there's now acceptance of that settlement. But um, he left open the need for a trial for pirated. So while there is, quote, some consistency in the second case against Meta, um, maybe not as well developed facts. The judge certainly found fair use for training. He seemed to also broaden that fair use to cover unauthorized copies. I still think um, there isn't clarity on whether or not fair use covers the initial copy. It seems to certainly, at least as both cases indicate right now, these are preliminary district court summary judgment, no trials had, certainly no appeals or anything higher than that had as well. Um, so I think a lot of people, especially non-attorneys, jump the gun and say we now have complete coverage for all aspects of training use of AI models because we have fair use. But I think we have to be cautious and look at the facts, whatever case you're involved in, and get proper legal counseling there.
Mhm.
It
Yeah,
seemed to me,
agree.
go ahead, Leslie.
Oh, sorry. I would say agree. I think fair use is one of those concepts that even among attorneys gets misunderstood, and I think everybody's seen the YouTube videos where somebody will post and say, "Oh, I'm not using this commercially, so therefore it's fair use." Yeah, fortunately, it doesn't work that way. I think people were looking for some indication on whether fair use was even applicable here. So I think it keeps the door open for fair use as a defense. But remember, fair use is a defense to infringement. And there are other claims. I think one of the other trends that was common to both cases is the causes of action for DMCA claims for removal of copyright management information. Those both got dismissed, uh, outright. So I think we're sort of seeing a trend, and again, trend of a very small number of cases, and obviously nothing precedential of, your causes of action are looking more like traditional copyright infringement. Um, and all of the cases so far seem to be focused against the producers or the distributor of the models. There isn't one really where you have a fact pattern of, say, if your end user is doing something that you know, generate some code for me that is like this project, and it creates some verbatim copy. You can you as a distributor can put technical protections in place to try and mitigate that, but it's difficult to prevent that entirely. So I'll be, if there's some fact pattern that comes up in the future where rights holders start suing individual end users of tools, and I think these cases are going to be pretty limited and sort of in the applicability of those.
And I think some of these decisions also turned on the notion that the model wasn't capable of providing a significant amount of the copyrighted work, right? So to the extent that someone produced a model that could provide that functionality, that may in turn kind of change the decision a bit.
Yeah, I think most of the large LLM providers, Anthropic and Meta, um, try to prevent that with filters on the front end. They try to filter the prompts to try to prevent the production, of entire copies of some original work. And then on the back end, should they be fooled by a certain prompt, try to catch it that way as well. But they're not perfect. And I think we're seeing, as usual, follow the money. The current plaintiffs are going after the likes of Anthropic and Meta, and to your point, not, a small company using it to produce marketing materials or something like that.
And I saw another aspect I needed to reread a couple of times in the Anthropic decision. And like we've said, this is lower court, so not really a precedence that I would go around citing in a brief. But the data store concept of, because the training data, the pirated training data, was being stored and held, the wording of the decisions placed emphasis there, in contrast to the transformative, taking the not pirated but authorized copies and using that as training data to then transform so that we have this healthier trained model, and not necessarily continue to store the training data. Somehow I felt that was being made as a distinction also under the guise of so-called fair use, to get that logic in as to where the transformation is happening, as opposed to holding on to pirated copies in a data store that's growing and continuing to be stored just as a sheer pirated copy. So I sometimes reread decisions to help myself understand, does the judge understand the technology? Because if any of this, let's say, happened closer to a real-time sort of pipeline in software with the training going on, there is no data store. Does that help us then steer clear of, as Leslie was saying, instead of fair use as a defense, we're just completely clear and not have a cause of action be alleged in that scenario. So I think there's a few moving parts and additional interpretations, and where we as attorneys place some emphasis or stress on these decisions.
Yeah, I agree. I think Alsop, I don't know the other judge well, but I've read multiple Alsop opinions. He is one of the more technically savvy judges. And I think it shows up, as you're saying, in his being able to distinguish between different steps. And I think he's basically saying the act of training using an intermediate copy is where he's focusing the fair use defense as being applicable. But if you're copying it for retrieval and storage later or some other purpose, well, maybe not. Again, all of this, as you said, is TBD from what we're doing. But I think I saw a more nuanced opinion with Alsop, where the Meta case, the judge in the Meta case, seemed to be taking a bit of more of a broad brush stroke to fair use.
Yeah. So, I mean, we haven't had the Supreme Court get to weigh in on this yet, and I imagine they will, but it looks like, at least in the Northern District, we're seeing some trending with, AI training being transformative fair use, with like a big asterisk on whether, on whether it's on an issue of whether it's lawfully obtained or unlawfully obtained copies that you're training on. That's still a gray area as to how that'll turn out. So, but in terms of the model itself, it looks like training the model is considered for transformative fair use, but we don't know. It depends on what it's being trained on.
Mhm.
Right.
And I think kind of a takeaway was pretty basic, is these cases aren't like an allowance to copy pirated data for purposes of training, right? Which is just kind of copyright 101. You're not going to get away with that. And these cases aren't allowing that, even though that future use of the data may be allowable. It's important to keep in mind.
Yeah, and in the EU specifically, there are rights for data mining, which a lot of people are considering AI training to fall under, but all of that that is explicitly predicated on having lawful access in the first place. So that's it's I think very similar to how the law is being seen in Europe.
Yeah, and the one thing I always remember from Europe is, and I think the data set was the Lion data set. There is an exception for researchers, but researchers can't act as data launderers. So if you do build a data set with the research exception, you can't then sell the data to a commercial company and have them train the model under the guise you're under the TDM, the text and data mining exception, which I think some early arguments were trying to be made along those lines, and I think they fail.
Sure.
So in terms of, open source versus proprietary models, there are huge benefits, obviously, to have open source AI for transparency and innovation, and it lowers the barriers for others to enter the market, accelerates knowledge transfer, and enables experimentation. There's so many good reasons, and it can also help with the community more involved. You can have more perhaps rapid innovation rather, and find new use cases that maybe a closed team or might not identify. But there's a lot of benefits to proprietary models as well. Although there's less transparency, you might have indemnities or get more protection from the provider. But from a legal and IP perspective, does open source AI complicate intellectual property enforcement and data privacy? If a model is released openly, who's accountable? If it's open source, if it was trained on pirated copyright material.
I think it makes a lot of the factors just more complicated and more intensive and expensive in a litigation context to actually figure out. Take a scenario of just like a general copyright infringement case of, hey, one of your developers took some code they weren't supposed to and put it in your product. In discovery, it will be fairly clear if the code was actually copied or not. You can do line by line sections. With an AI model, you have to get into questions of how it was trained, how was the data prepared, what is it capable of outputting. It increases the complexity and the lack of case law guidance showing like, well, does this fall under fair use? Does it not? Really shifts the risk, to a deployer. I particularly with open source models, I think you almost have to treat as, it's a black box. You have to take it as is. And if you want to deploy it, particularly as part of a product, if you introduce a problem for your customer, they're going to come to you.
Right.
So as a practical matter, I think it's going to be you as the deployer to sort of do your own vetting, and what the answer for that is depends on what your risk tolerance is. A startup might be happy to take a model off of Hugging Face, run it on their own instance, and say this is good. And for some businesses that might be, perfectly fine. Other suppliers not so much. If if your typical customer is a Fortune 500 company, they're going to want to see a little bit more due diligence.
Yeah. We're seeing similar, to your last point on customers. They are very nervous in general. We're a managed infrastructure services company. So we provide services to, many of the Fortune 1000 to help them manage their data center and their IT infrastructure from desktop to server to network aspects. And sometimes I believe they don't even know why they want to know, but they want to know what we're doing with AI because, they've heard hallucination, they've heard the horror stories about what can go wrong, and they want to know about, what we are doing. You know, when a company like ours looks at the question, should we look at an open source model here or proprietary? A lot of the points were touched on. It's too simple a framework, but to me, it comes down to convenience versus protections. Um, you know, you gain some protections if you bring the model in-house and you're working with it yourself. Um, and I'm thinking about the components of an AI model or AI system being everything from the neural network model itself, untrained, training data and tools that will train it so you get a pre-trained model, quote, general pre-trained transformer model if the neural network is that. Um, And then, once it's trained and it gets released, you have to look at, I think, the open source AI model providers as to how deep they're going in, quote, open sourcing all of that infrastructure. I think very often the model itself, the pre-trained model, they all seem to provide that in my experience of looking at them. Some provide weights to it, the ability to fine tune and tweak the performance of the model. Some go further, I think, and basically give you the training data. And someone was mentioning earlier the privacy issues. I think that's where a lot of exposure comes. Certainly, if it's trained on PII, it has the potential to output PII. And again, I think if you're working with commercial providers, you're getting the advantage of some filters. If you're working with an open source model, you lose that convenience, and you have to wrap some things around it yourself. Leslie pointed out, there's literally hundreds, if not thousands, of models out on Hugging Face. I think of it as the GitHub for AI models. But you're not getting a lot of protections, and the quality can vary greatly as to who's posting it there. We tend to look for large companies who are making available open source versions of some of their models. Think Meta and Llama, think IBM and Granite. Those are the kind of models we put in the candidate pool for open source AI model looking. But as Giovanna was indicating, you lose on the output side potential indemnification. When you're rolling your own open source model, you're rolling your own indemnification as to what you can do. Maybe you can sell it to customers as is, no protections, but they've seen from the major model deployers, Microsoft, AWS, Google, others, Meta, Anthropic, some form of indemnification, and they want it. Are you going to stand behind that yourself? In-house, you've got protections for confidentiality, the storage and training. When you're working with a third-party commercial model, if you're paying for it, you generally can maintain confidentiality of your data that goes into it, your prompt. You can specify that they don't train on your prompts and they don't store your input or your outputs for that. But if you're not paying for it, those are generally open for the vendor, for the model provider to utilize. And bad things can happen there. But you pay for the commercial side. There's a cost even to rolling your own with an open source AI model, just as there always has been for open source software. Everybody says, well, it's free, it's royalty free, but there takes something to download it, build it, package it, test it, certify it, deploy it. And that's basically the business model of some large open source vendors like Red Hat. Every bit by bit, everything they distribute is available in open source, but you're not getting the convenience of having it bundled and getting it in a distro, getting support and subscription updates to it. So there's a cost to roll your own as well.
So you described a nice kind of pipeline workflow. How early on should the attorneys, the legal departments, be involved then on these software development projects?
I'll make a short comment that won't be surprising, and I'll let others chime in, which is our goal is to get embedded with the team as early as possible and for them to see legal as an asset, not a final check and clearance, because then your role is, interference at that point, because they've already invested so much financially. At that point, it gets a bit emotional. We've spent a lot of time on this, we believe in it, and you're throwing a wet blanket because of the licensing situation or the risks, associated with a lack of indemnity. So early and often is my answer.
Yeah, same. I've had very similar experiences, and you don't want to be the person that's putting the no if you hear about something sort of last minute. Oh, hey, we've tested it, we're ready to roll it into production, and then you have to say, well, that's a non-commercial license, even if it's true and it's entirely blocking for you. It's just a complete no-go. You're still seen as the one, being the barrier.
Yeah, they shoot the messenger.
So it's almost sort of the shift left philosophy that some people use for software development of, the closer you can get it to development time, the less effort and the less time and money you've put in going down a path that you ultimately can't follow.
Yeah, I completely agree that, I think most attorneys would say legal should be involved from the start, right at the model selection age, definitely not at the launch,
Mhm.
But, early involvement lets, counsel, they get to vet the model licenses, the training, like data provenance, like where it came from, was it, legal, lawfully obtained. We want to look at the vendor terms. We want to see, if there's indemnities in there. We want to see and make sure that, if our data is being our input data to the model is being re-ingested into the system, if it's being trained on it. Legal should stay engaged throughout the whole integration process, and want to make sure like all contracts and IP ownership and privacy and regulatory documentation, all that stuff needs to be aligned with legal and engineering and all of the governance requirements of the enterprise.
And I think, to some extent, maybe the legal involvement can help streamline the technical processing, in that there are gating issues that will just allow you to help expedite maybe your selection process, right? There are just some terms that are going to be unacceptable. And so maybe that helps kind of funnel you down to a limited number of choices that would help.
Yeah, the approach I've taken, I've sort of, there's almost like a coarse filter and a fine filter phase of, and you can provide sort of general level advice for everyone. Like, here are coarse filters. These types of licenses are just unacceptable for our use case. Non-commercial, or something that doesn't, wouldn't fit for our own customers. Examples like that. That doesn't mean, you can sort of be out of the loop entirely as the lawyer, but you can provide guidance on sort of, these are the known no's. And
Yep.
then after you get past that for your development teams, then you get into the fact specific questions like, well, okay, so what is the provenance of the training data? Have questions about the workflow and whatever you need to address sort of case by case.
Right. And you being our regulatory expert, especially for the EU, I mean, that we need to, compliance is a big issue as well. So, for the AI, go ahead.
Oh, I'd say, and just from a regulatory compliance, the AI Act in the EU has a lot of transparency obligations, and so do certain U.S. state laws. California and Colorado are requiring a certain level of transparency. The law itself doesn't go into great level of detail of how much is required, so I think that's going to be a somewhat evolving standard. But these questions that we're asking about, how, who's doing the training, what is the provenance of the data, what you're going to need to have to basically publicize some level of detail on that, due to these regulations. So this isn't just legal being a blocker. This is, well, we're going to have to be gathering this information anyhow. So how do you develop the processes to sort of standardize, standardize and collect that data, because your customers will be asking for it, regulatory bodies might be asking for it, and you don't want to be stuck saying, well, we just pulled it off Hugging Face, so we don't really know. That's not going to be a good answer.
Right.
Yeah.
So we're probably going to be needing to produce the model-based SBOMs, M-bombs, if you will, right?
Yeah.
So then that'll, should include maybe the weights, like details about the weights, the data sources, the data sets that it's been trained on, any dependency models. I mean, this is an evolving area to see what we're going to need to comply with these regulations, but it's likely to be, some SBOM standard for models.
Yeah, I think transparency is going to be one of those issues that just continues to be more and more important. And somewhat in the category, at least as I understand it from the EU AI Act, of traps for the unwary. There is an open source exception within the EU AI Act on the transparency, I think under the guise that, well, it's open source. But as soon as a company takes that open source model and uses it commercially in some way, incorporates it into a product or an AI system they're either using to provide a service or to distribute to end users, you lose that exception, is the way I'm understanding it. So just like you'll hear, I have heard some of our senior executives, soon after the end of June say, oh, all AI is covered by fair use. I'm also hearing, oh, we're using open source AI. We don't have any transparency requirements. It's open source, so there's no requirements for us. But to your point, Giovanna, we are very much likely in a commercial environment to be teeing up documentation of an SBOM or an MBOM or, as you said, training data sets. If we have to produce that, we're going to be looking from the provider. And if that provider is an open source community or two guys in the garage posting a model to Hugging Face, there's, as you said, we've got to get involved early, and these guys say, I really love this model. And it's, well, what's the licensing? Are they giving you transparency information about it so we can satisfy our obligations? They might not have them, under the exception, but we don't so benefit. And, again, I hear executives every time there's an exception, they think it swallows the rule. They want to drive something through the exception.
Yeah, I would be very careful about the open source exception with the AI Act. There's also the Cyber Resilience Act, which is more focused on cybersecurity. That has some open source exemptions that are fairly generous. That a lot of that was from comments that open source foundations provided during the comment period for that law. But the AI Act one specifically, so they address different risk thresholds of minimal risk, high risk, prohibited risk. If you're high risk, commercial or not, you don't get that exception. There's also if you're a systemic risk of if you have a model that is basically has extremely high market penetration within the European market, you could lose that risk basically by decree from a regulatory body. There's also, I believe it's Article 50, which goes into certain use cases, one of which is if it's a generative system that is able of producing synthetic images, text, or video or audio, you lose the open source exemption. Well, to me, that's the vast majority of generative AI systems. So
Yeah, the LLMs,
that
sure.
yeah, that's so that's a very I don't want to say that's a minefield, but that's a area where I think you have to be very cautious, even as a non-commercial entity, um, producing models.
Right now, do the exceptions do they apply to researchers? So to the research community, because I noticed some of the open source models or that have hybrid proprietary and open source licensing, they will have a different licensing model, an open source licensing for researchers, but a different a proprietary model only available for enterprises. And I was just wondering if the open source sort of exceptions with the Cyber Resilience Act and the EU AI Act, if they would apply to the research community. If it's
For the Cyber
Yeah.
Resilience Act, more than likely, because it very much scopes around, are you making something available in the market in a commercial sense? Yeah, and there's some gray area in there because you have some projects where they say release it open source, but they might have a consulting company separate on the side where you provide support for that code. Those are kind of in a gray area. But if it's just a pure research project, you're in academia and you're releasing something open source, you'll likely fall within the exceptions of the Cyber Resilience Act. But the AI Act, not really. It's, are you distributing a model that's available within the market? It doesn't have a lot of the same commercial, non-commercial distinctions. So I think that's
So it
again,
just
point
turns
to,
on availability. Like if you couldn't do the situation where you make it available but sell consulting services or support services, that would still run afoul of that exception.
Yeah, that's my understanding.
Okay.
So of course, this is all, this isn't, it's in effect, it's in force, but a lot of these regulations aren't fully applying until next year. Some I think are until 2027. So how this is exactly going to be enforced is still to be seen.
Right.
If you look at, say, GDPR enforcement, for example, and regulators tend to take a soft approach. Some companies seem to be more targeted than others for various reasons. But I think we'll see an enforcement model similar to the GDPR of where fines usually start out pretty small, for first offenders under GDPR, you see fines as little as 10,000-15,000 euros, which is for a large company, financially minimal, but you don't want to have the news, the articles and things written about you of, oh, you were fined for misusing somebody's data in some way. But then you can have follow-on fines get into very large sums. The Cyber Resilience Act is very similar to the GDPR in that the maximum fine is related to the total turnover of your company. I believe it's 2.5. The maximum fine, I believe, is 2.5% of your annual turnover as a company, which is, for larger companies, that could be billions.
So in the US, we have some some regulations percolating, and we're especially, we don't have any sweeping AI law yet, but there is, a bit of a patchwork of initiatives going on related to AI and national security. And, state legislators like Colorado, California, Texas, they've been passing their own rules, regulations related to AI. And we've seen some new legislation related to deepfakes. But, in California's AI law, that requires AI generated content detection tools and watermarks for like larger platforms, right? And so these kinds of regulations that are coming up, and it makes the freedom to operate for innovators in this space even more complicated, especially, trying to standardize the system with all of these competing and regulations that may require companies to do things inconsistently in each jurisdiction. So it's
Yeah, it sort of brings to mind that, well, it's included in the transparency conversation we just had. We mostly focused on the input side. What did you use to train the model? But as you say, alerting the end user that they're interoperating with AI, like in a chatbot. We don't really know. You're typing your question and it's giving you an answer. Are you a human, or is this an AI generated response? I think depending on which jurisdiction you're in, there is some transparency requirements. If you do produce the output, is it watermarked? Is it obvious to the consumer of the output that this was generated by AI? And then, of course, the videos and audio outputs that, utilize the name, image, likeness of a person, they generally, because they can, create deep fakes, they generally, I think, have more strict regulation than a text output or even an audio output. I think the videos do, but transparency goes across the spectrum from the input you use to train to in some jurisdictions, how transparent you have to be that you're interacting with or reading or consuming something that was generated by AI. And I think I have not looked into the legislation in the US, but as I understand it, something named the LEAP Act, and don't ask me what the acronym stands for. It is a bipartisan bill that's floating around, I believe, the House. Whether anything becomes of that at a national level, I think remains to be seen, especially in our political environment. But that's at least being discussed, as I understand it.
And it is interesting to see the approaches that different states are taking. Utah, for example, has a law that was passed. It was an amendment of their consumer protection law, but it was around notifying that a consumer is interacting with the chat, with an AI system, with a chat bot. like Steve mentioned, a lot, some other laws are focused around right to likeness. I think California has a separate bill from their comprehensive AI law. Tennessee as well, for same reasons it has an indefinite term to right to likeness. So other states are focusing on employment or health related issues specifically. So for the attorneys in the audience, if you're doing your research, you can't just focus on what are the AI laws, because the states are being very creative and fractured on how they're addressing this. Texas, the state where I'm barred, passed a data localization law. So there is some references to AI in there, but you can't look at just that one bill. It's basically a requirement that any health information of Texas residents must remain in the United States. So, if you're training with PHI, personal health information, okay, you can train that model. You can, that law doesn't affect that. But then what happens if you have a European customer that wants to use that model and then run it on their local environment, on a European hosted environment? Though, there's a lot of minefields there. Particularly if you're in a industry that I would say is more litigation heavy or regulated, like employment, leasing, things like that, where you have a lot of, I don't want to say low stakes, litigation, but litigation is common and kind of transactional. You have to really focus in on what your use case is for your AI model as a deployer or as a user.
Agreed.
I need to
go-
correct the record. It's the LEAD, LEAD Act. I just looked it up, not the LEAP Act. Aligning incentives for leadership, excellence, and advancement in development. So
right.
it's a
Well,
Senate bill,
I think one of the takeaways here is, we don't wait for a comprehensive law. We want to make sure that we're implementing internal governance, with bias testing, security checks, transparency with users, letting them know, that you're talking to AI, just now, start implementing these things now, or with the option to have that kick in, have it be ready, so that we can make sure that we comply with all of these emerging state rules and the broader international and national interests that we're seeing things moving in that direction.
True.
So,
I always have to chuckle when we start talking about state jurisdictions, boundaries that are geographical, because the software doesn't know those boundaries. Even if the server, the provider is incorporated, housed, and situated in a specific jurisdiction, state, all the different users, all the different access to that software product can come from all the different jurisdictions in the US as well as worldwide. So you're right, we have to, from a advisory standpoint, be ready to apply I'll say probably the most conservative position to begin with transparency, and as you were saying, even to the extent of making it an option that the end user has some sort of warning, informational, some tidbit to help them understand this is an AI generated response or model that's being used, whether it's within a chat or some other functionality. So I do appreciate that it is very patchworky, but the software actually will not know these particular jurisdictional boundaries.
Yeah, and having been in software for a little bit, in most large companies do have worldwide deployment.
Yeah.
Often these days through hosted deployment, SaaS. But it is very difficult to fork that and have one-offs for countries or certain clients. So we tend to go down to the settled, least common denominator, conservative approach that you mentioned, just practically. It just because we cannot support, 50 different versions for use in the US, much less, doing business in 50 countries around the world.
Yeah. And for privacy specifically, I know, some companies take the approach of, yeah, particularly if you're just selling in the US, of, well, California has the strictest privacy law, so we're just going to comply with that. And, just as a risk acceptance policy, sort of, we'll comply with this, and we're assume that that is a baseline is compliant with every other states. I think because of the fragmentation and how just within the US, how different states are addressing this as sort of through employment or modifications of the health data, or pseudo IP rights. It's more difficult to do that, but I think at the end, you're a business, you have to be able to sell eventually. So it's where you draw that line is, I think, is the the fine art of it.
So we're approaching the end here, so we want to answer some of our questions from our Q&A. We have a question from Steve Karp, one of our other a friend of ours from our open source group that we get together with. And he asks, do you have any particular recommendations regarding governance models or workflows that particularly work well for cross-functional alignment, legal, product, security, engineering? So
I can take a stab
sure.
from our point of view. We certainly, we publish principles, 5 principles. I don't know that there's a company on earth that doesn't publish principles. They're motherhood and apple pie. Don't be biased. Use a human in the loop to check things. All good hygiene. But beyond that, internally, we apply governance, I would say, largely in 2 places in the workflow. One is the supply chain. So we develop an inventory of approved AI systems based on their terms. And we have our developers and our account people that work with customers source from that inventory of approved vendors. That gets you some comfort, and we look for those things that I mentioned before. We don't want them training, we don't want them storing, we want them keep our data confidential if we're using third parties. We want indemnification as broadly as possible on the outputs. Those are kind of table stakes for our supply chain providers. And then we do use case analysis. And this is more for, are you building a high risk AI system, as the EU AI Act kind of defines? Are you building a general purpose AI model? All of which, in my simple analysis, are the focus of the EU AI Act, which is high risk general purpose AI models and systems. So we do a use case analysis, and we basically say, what are you using these vendor AI models to build? What is your AI system purport to do? Is it making any guarantees? As we talked about before, is it being transparent? We don't want to indemnify for its outputs if we can't control the inputs somehow. Because most of the indemnifications from the vendors come with carve-outs, a lot along the lines of, thou shalt not intentionally ask the model to produce something that is a copyright infringement. So, the example I always use is, you can't say, draw me an image of Mickey Mouse. Because, well, it may be able to draw that if you distribute it and you rise to a certain level, I guess. Disney is going to come after you for that. These are highly copyrighted and valuable. They're copyrighted and highly valuable works. But those are 2 points in governance that I kind of consider pinch points, is try to get protected suppliers and try to make sure, the use case isn't off the wall for what they want to do.
Yeah. And I think that there are like NIST standards and ISO standards that align with exactly that relate to AI management systems. And, they kind of go into like having a first line being like engineering and product. They're, just having them responsible for the model design documentation and the SBOMs and the, model bombs. And then the second line would be legal, privacy, and security, providing, the policies, the oversight, the governance, the regulatory, make sure we're regulatory ready. And then the third sort of dimension would be the governance and audit committee, so that would be reviewing the AI for risk, like having an AI risk register or something like that, incident reports, audit logs, making sure that we have a clear trail of the system. So we have another question. We could probably take one more question here. And it is about GitHub. If you post your code on GitHub, which is required for many academic publications, like any considerations for the best license to submit it under? Also, are there any non-traditional business models for these types of inventions?
So I used to work in academic IP licensing, so I'll take this one if you
Sure.
don't mind. So first, as a grad student, check with your tech transfer office. Your university may own your code, not you. Shout out, but generally, I and most tech transfer offices will be aware of aware of this. Students post to GitHub, and it's a requirement for publication. It's a requirement in some grant agreements now. So that's not unexpected. The best license, I think, is a practical answer. If it's on GitHub, it's exposed to the world. At that point, you should just, I would lean towards a permissive license. I mean, that was certainly, what I coached a lot of grad students and young faculty is like, is this something that you're ever going to commercialize, or is this something you're throwing across the wall as a research artifact? If it's a research artifact, you have no intent to commercialize. Most tech transfer offices are not going to be actively, slapping people on the hand for saying, "Hey, you shouldn't do that." They understand the environment they're in, so I would just take something permissive. Talk with your particular tech transfer office, even if it's not something the university owns. Most will be happy to sort of have have a high level discussion on those things. But your university may have requirements for a particular type of license or a preferred license. In terms of a business model for those, it's that could be its own webinar. It's licensing through the university is one. I've been on both sides of that as the university and as and on the corporate world. That is certainly a thing, but it's difficult. Certain companies have sort of tried smaller micro licensing of basically almost licensing snippets or proof of concepts at a simpler route than traditional tech transfer licensing. And then there's, I've seen students and faculty do this with, you release the code as an academic under an open source license, and then you go start your consulting company or a startup as a user of that open source license. It's, there are qualifications to that. Again, the university may own the code and have its own IP policies that interfere with that. But it's possible,
Yeah, I'll add 2 cents on the licensing choice. I think, 10, 15, 20 years ago, it was a pretty simple calculus. If you wanted to be commercial friendly, use a permissive license when you contributed your code, because companies were, sort of outlawing and preventing the GPL and copyleft software from being used. These days, I would argue it's a philosophical choice. Um, Companies have learned how to deal with copyleft licenses, how to keep the separation, how to use it separately. And most that I've ever dealt with are comfortable with that. And the philosophical choice is, do you feel philosophically tied to, I want to keep this freedom, um, you know, freedom to license under this license pure and intact, then go for a copy left. Otherwise, Apache, MIT, very common, very popular.
Yeah, I would agree with all that. And also, if you want to have a proprietary potential option, then doing a copy left might be the way to go, because you could have the option to dual license it as under a proprietary license. And with the copy left, GPL can give you a little more leverage to options. For some companies will want to take the proprietary license so they don't have to deal with the copy left. So it might give you some more control once it goes upstream over different licensing strategies for the future. But it's all a very strategic approach. And we're at time. So what's clear today, from today's conversation, AI isn't just about changing technology, it's about changing how we think about risk, ownership, innovation. So, ultimately, I think we want to build trust with our customers, our partners, and our regulators in the AI space, in this new AI-driven world, really. So as we leave you today, I hope you continue these conversations offline, with your team, in your industry, and of course with us. AI is moving fast, and thoughtful collaboration between technologists and legal professionals is how we make progress, and both responsibly and enduring. So thank you so much for joining us today, and super thanks to Mary Lou, Phil, Leslie, and Steve for sharing such rich and practical insights. Thank you.
Thanks all.
Great
Thanks.
conversation.
Yes.
Bye.
As always.
Super. Bye-bye.